The Senzo Meyiwa murder trial has been postponed to Monday to determine the way forward after advocate Zandile Mshololo, representing accused number 5, charged at the state for what she termed failure to disclose crucial evidence. This relates to the existence of a second docket, which names people who were in the house, including Llewelyn Curlewis, as suspects. For more on this, I'm joined by Llewelyn Curlewis, a criminal law expert at the University of Pretoria. A very good afternoon to you. Thank you for your time. As we saw all of this unfolding and playing out in court yesterday, what was your legal analysis?
Yes, we had a surprise yesterday when it came out in court that there's a second docket, allegedly informing the court that the previous decision by the National Prosecuting Authority in Gauteng South materially differs from the decision that was made from the NDPP's office in Gauteng North. That in itself indicates that at least 2 different directors of public prosecutions came to 2 different conclusions regarding who should be accused of the murder in this instance. Now, all in all, obviously, the legal team of the defense, the accused, will definitely do anything and everything in their power to persuade the court that there is something untoward going on. Because in the bigger scheme of things, it's indicative of the shortcomings or possible shortcomings in the state's case, and the question then arises whether the state will be successful in proving beyond a reasonable doubt that the accused before court are the guilty parties.
The other aspect that came up, of course, was Judge Chifiwa Maumela really at pains emphasizing that this matter should not be delayed any further. It has already seen delays, and what needs to be considered is that people are in custody. There's a family that buried a son, and the country has lost a remarkable person. Certainly, perhaps setting the tone for the time frames that should be considered when the team comes back again on Monday to chart a way forward.
Yeah, definitely. And obviously that is of prime concern to the court. The court must see to it that justice is determined expeditiously. The fact of the matter, however, is, and correctly pointed out by the defense in this instance, if they are only given a docket with new information on the morning of the proceedings, being yesterday morning, then surely they are entitled to peruse it and prepare properly for the continuation of the cross-examination. It is as if the state prosecutor actually is busy with a trial by ambush, so to speak. One would have expected that somebody of the seniority of Advocate Baloyi acting for the state would have provided the defense with all the information they required and are actually entitled to from a constitutional point of view from the outset, or at least then some weeks ago, not on the morning of the cross-examination itself. So that is something that raises concern, and definitely the court should also be concerned about that state of affairs.
So where does this place this matter now? Because they will be sitting to deliberate and see how to move forward, but there are 2 dockets. What does it mean for the entire investigation and the case?
Well, at the end of the day, it's not a question of it will favor or disfavor the state's case necessarily. It will depend on the contents of the docket. Currently, under cross-examination is the investigating officer and the question, or the responsible for the forensic scene. And the question then arises whether there's a different statement made in this latest docket 375, which is known as. If there is, then the issue is the credibility of the witness at stake, because he made different observations or different statements on the 2 separate occasions or not. If the contents is materially the same, well, then obviously there's nothing to be afraid of from the perspective of the state, and it will not, that will not be the end of the state's case. It's like a puzzle. Each and every issue, whether it's a statement that's made, whether it's the credibility of a witness, all of these will have to be weighed up, and the evidence attached to each of these individual pieces of evidence ultimately then forms part of the bigger puzzle. And remember, where there's doubt, the doubt must always favor the accused, and they get the benefit of the doubt because the onus ultimately is on the prosecuting authority. And if they are not successful in proving their case, and the threshold is high because it's beyond a reasonable doubt, then the ultimate acquittal will follow in favor of the accused.
Could the state face repercussions for this non-disclosure?
Repeat the question, sorry.
Could the state find themselves in a position where they face some form of repercussion for failing to disclose this second document?
Absolutely. You can be guaranteed that the defense will argue that the states are busy with all kinds of politics and tricks and illegal kind of tactics. And I won't be surprised if some interested party, maybe even the court, at some level, at some stage, refer the matter for a disciplinary investigation against either the SAPS members responsible for it or even the prosecutor involved. Whether something will ultimately come from it, that depends on the ethical behavior that will be determined after investigation into the conduct of whoever was responsible to disclose the information to the defense comes at stake. But that is a separate decision and a separate investigation at a separate trial later on. Got nothing to do with this specific trial. In this instance, it can only have an impact maybe at best in favor of the defense against the state's version, which will ultimately then boil down to a possible acquittal.
Very well. Thank you so much for that analysis. Llewelyn Curlewis, a criminal law expert at the University of Pretoria.